Good morning, everyone, and welcome, and thank you for joining us this morning for part 2 of Roetzel's Road to the Budget Bill, the Senate version. This webinar is presented by Roetzel and Andress LLP and Roetzel Consulting Solutions. My name is Susan Anderson, and I'm a shareholder at Roetzel and Andress, and I'm the practice group manager of Roetzel's Education Law Group. Joining me today to discuss the Senate's version of House Bill 33 is my partner, Lisa Burleson. She is a shareholder and member of the Education Law Group at Roetzel, and Sherri Warner of counsel with Roetzel and Andress and director of Roetzel Consulting Solutions. So as you all probably know, Senate Finance just passed their version of the budget bill on Tuesday. So today we are focusing on the provisions of that version, and we'll highlight in particular what is modified in the Senate Finance version from the prior House version. And we will also quickly touch on what's been eliminated in this version and what's been maintained identical to what was in the House version without change. Sherri will also talk to us a bit about the status of the bill at the Senate and the potential pathways that the bill may take as it heads towards final approval later this month. Just as a quick reminder, any opinions that we express today regarding, either the prior history of the bill or the path that it may take are just our opinions, and they don't represent any opinions of any members of the legislature or any legislative body. Finally, I would be remiss not to mention that this is part 2 of a 3-part series, and so we will be scheduling part 3 once the final budget bill is passed. And so we are looking to do that right now, tentatively on July 6th, but that date is subject to change depending on when final approval of the budget bill actually occurs. But circling back for our purposes today, we do intend this to be just really kind of a quick touch point on the provisions in the Senate Finance Bill. And we have a lot to cover, so we're going to go ahead and jump in. And for that, I will shoot it to Sherri. Sherri, the floor is yours.
Thanks, Susan. So real quick on where the budget is currently. The budget was, the substitute version, which we are working off of, was proposed in Senate Finance on Tuesday of this week. The bill will be there until probably Tuesday or Wednesday of next week, when an omnibus amendment will occur, and then the bill will be moved to that Senate floor. Once the Senate votes on it, the bill will then have to go back to the House, and this is where things get interesting. In a typical year, the House would refuse to concur, send the bill to a conference committee. The conference committee would work out all of the changes, and they do that in conjunction with the governor, and then it would go to the governor, or would go back to both houses to accept the conference reports and to the governor for signature. There has been a lot of conversation around Columbus this week that rather than sending the bill to conference, there is an attempt by the Senate to have this bill in a place such that the House will simply concur to all of the Senate changes. Now, I don't know the likelihood of that. It is certainly would be a wrinkle we are not have not dealt with in the past. There's a tremendous amount of language and changes in this budget bill as a whole. So making that all happen would be a yeoman's lift, but I do know it's something the Senate is talking about and trying to have happen. So the typical schedule of everything being done June 30th may change based on what I've just said. So we're going to start with things that were in the budget bill that the Senate did not change. The Senate made no changes to what you can do with your DPIA funds or your student wellness funds. They also made no changes to the area of the pre-service teacher permits. The House, in their version, you'll remember, changed the teacher licensure bands, and the Senate concurred or has left those bands alone. And finally, the dyslexia professional development training has also been left the same. There was an increase in the stipend back to what the governor proposed. Next slide. Provisions that the Senate removed. So these are provisions that either the governor or the House put in. They were certainly provisions that the House had in their version, but the Senate has removed them. So the baseline increase to the teacher salary schedules was all removed out of the bill. So it currently is not there. Also, The language regarding the student resource or the school resource officers, which the governor proposed, was removed. The governor proposed and the House had agreed with providing requiring the Department of Education to have dyslexia screening measures. All of that language was removed. And something to remember is, as I say, these are as versions as passed by the House. The third grade reading guarantee, which was removed in the House, was added back in the Senate. So your third graders do have to pass the test in order to continue to fourth grade. Your professional development leave, there was a provision in the House which said that all school districts must allow 1 day off for all teachers to go and view a veteran teacher. That language was removed. The requirement that your coaches have mental health training was removed. There was language put in the House that made changes to the language around requirements with regards to transportation of private and community school students that attempted, I think, to level the playing field with regards to all of the students are treated in the same way with regards to priority. That language was removed. And finally, there was language in the bill that would have reimbursed all of the districts for the free and reduced lunch plans and breakfasts. That language was additionally removed. In the next section, these are sections that were currently in the bill that the Senate has made changes to. And obviously, the big change came in the foundation funding formula. They did tweak the formula some. I don't think it was the wholesale change that many thought was going to happen. They kept the funding formula largely intact and kept it at the FY22 cost inputs. They did make some changes to how local share is going to be determined. So money will be shifting some from within the formula from district to district. But their overall changes only reduced school funding in this space. And you can go to the next slide. By approximately 280 million in fiscal year 1, and then a little over 300 million in fiscal year 2. You can go to the next slide. We're going to move on to the JVS formula, which is on slide, I believe, 7. That formula was also left mainly very close to the same, with the same types of tweaks in it that were given to the foundation formula. And the gifted funding formula on slide 8 had similar, or slide 10, I guess, had similar changes. The next thing I'm going to discuss is the dropout retention, which the recovery schools were modified slightly. There's a great expansion in this area. They're really trying to get students or individuals who have dropped out back in to school. And then finally on slide, we're going to talk about the Ed Choice Scholarship. With the Ed Choice Scholarship, which is on slide 18, the Senate made a significant expansion on that scholarship program. They kept everything in place that the House and the governor had proposed, which was a voucher for anybody up to 450% of the federal poverty level. They then said any other student would be able to have a voucher, but it's going to be means tested based on your income, with it gradually being reduced as the family's income goes up, with a minimum scholarship of about 10%. Also, the scholarship will be based on the scholarship, the funding formula's baseline costs. And so it looks like the scholarship in the first for K-8 is going to be about $6,000, a little more than $6,000, and for 9-12 will be up in the $8,000 range. So having said that, that's what's going on in the funding, the general funding space. And with that, I'm going to turn it over to Lisa on slide 19 with the sports gaming tax revenue.
Yes, so as we recall from the first webinar, we discussed the fact that the House proposed to reduce the required allocation of the sports gaming tax revenue to the earmark for K-12 athletic and extracurricular activities. The House proposed to reduce the required allocation of those funds to the lesser of 15 million or 50% per fiscal year. And the Senate completely removed the required allocation. So now the proposal as set forth by the Senate for the sports gaming tax revenue, generally speaking, those funds can just go into GRF for general use. There's no longer in the Senate plan a requirement for the allocation specifically for the earmark for K-12 athletic and extracurricular activities. So we'll stay tuned to that to see what ends up in the final version.
Okay, so in regards to resident educator, the Senate finance version largely maintains what was in the House version, which is, one change, which we will discuss. But if you all may recall, in the House version, the budget bill incorporates the changes that were made to resident educator through House Bill 442, which reduced the program from 4 years to 2 years. Some of you may be in the process of negotiating those changes with your teacher unions now in your collective bargaining. Also in the House version of the bill, it does permit the required mentoring to occur either online or in person. It does also require ODE to provide participants and mentors with no cost online access to certain resources. And then it also requires ODE to provide online instructional coaching to those that do not receive a passing score. Of particular interest, I think, to school districts is that this is in the House version and also maintained in the Senate finance version, that it does permit participants in the resident educator program who have not done the program yet to meet with instructional coaches if the participant's school district will pay the associated costs with the meetings. So I think this is something, if that provision gets maintained in the final version of the bill, I think this is absolutely something you will be seeing at the bargaining table with your teacher union seeking to get an agreement by the school district to, pay for that instructional coaching that would now be permitted. One of the changes in the Senate finance version from the House version is basically that they make the license generally renewable without requiring the holder to actually go on to the professional educator license. So with that, I will toss it back to Lisa.
So when we in the first session discussed the autism scholarship intervention provider piece that the House introduced in its version, recall the governor did not have a piece on this in the executive budget. The House introduced a proposal to allow RBTs and certified behavior analysts to qualify as providers of intervention services under the autism scholarship program. And in the House's version, the House also indicated that an educational aid or other aid permit would not be required for RBTs and certified behavior analysts to provide these services, the intervention services under the autism scholarship. The Senate took the House's proposal. So this concept of including RBTs and certified behavior analysts as qualified providers of intervention services is still included in the Senate's version of the autism scholarship program, but the Senate took that proposal as introduced by the House and added to the RBT piece that RBTs, in order to be qualified intervention service providers under the program, they have to be under the supervision of a certified behavior analyst. So that's the change that the Senate proposed to the House concept on intervention providers. What we don't have in the slides, but what we are also watching is the Senate proposed to expand the eligibility criteria for the autism scholarship to include those students who have merely been diagnosed with autism, and also those students who are currently receiving services related to autism. So those are two pieces that we'll continue to watch in the Senate version. And that again relates to the Senate's proposal to expand the eligibility criteria for the autism scholarship.
Okay, so in terms of school vehicle authorization, Senate Finance, again, largely maintained what was in the House version of the bill. And that version authorizes a school district to use a vehicle that is designed to transport 9 passengers or fewer, and would allow for greater flexibility in transporting students to a chartered non-public school if certain conditions apply. And those conditions are that the number of students in the vehicle do not exceed 9, the district regularly transports the students to the chartered non-public school, and the driver has a valid driver's license, is accustomed to driving the vehicle, and meets other statutory and administrative requirements. So that's the same version that's in the Senate Finance bill, but they did, the Senate Finance Committee did also authorize transporting students in the same manner to community schools and not just chartered non-public school districts. The Senate Finance version also extends this authorization to community schools and chartered non-public schools in similar ways. Next slide.
So in our first session, we talked about this People Transportation Pilot program that was introduced by the House. The governor did not make a proposal on this particular issue, but the House did. And under the House's plan, there were to be 5 ESCs who would pilot a people transportation program in conjunction with identified school district members of each of those 5 ESCs. The program as proposed by the House was supposed to begin August 1st of this year. And the pilot program itself was to be in collaboration between ODE and the Ohio ESC Association Program Cabinet. And there was supposed to be collaboration on not only the program itself, but funding for the upcoming school year. And at the end of the pilot, there were supposed to be reports of the pilot program, the implementation provided by July 1 of 2024. The Senate kept the concept of the people transportation pilot in place, but changed it pretty significantly. So first, the Senate reduced the number of ESC participants from 5 to 2. The Senate also removed the ESC Association Program Cabinet from the collaboration piece and moved the responsibility of oversight and implementation for the pilot to do. That's that new version or new arm of the Ohio Department of Education, which I think Susan will be touching on here shortly. And the 2 educational service centers that are remaining in the Senate's proposal are specifically identified by not only the population, but their location. So the Senate said for ESCs, the 2 ESCs participating in the pilot program, one will be located in Central Ohio, Franklin County, and the other will be located in Southwest Ohio, Montgomery County. And so the program now in the Senate's version will be delayed a bit. The program rollout will be due in October of this year rather than in August. And the report from the pilot findings program implementation will now be due in the fall of 2025 rather than in July of 2024. What perhaps is most intriguing about the Senate's proposal is the ESCs that will be participating in this pilot program for people transportation, and that will include pupils enrolled in community, STEM, and chartered non-public schools. Probably most compelling is the ESCs under the Senate's version will be required to arrange buses and bus drivers And Do, the new arm of ODE as being proposed, will handle all the funding. So it'll be interesting to see this piece and if it sticks in the final version, and will be certainly interesting to watch as the pilot rolls out.
Okay, so next we're going to talk about things that are new in the Senate finance version of the bill. First is the sweeping changes that are being proposed to ODE, as most of us know it to exist. In the Senate finance version, ODE would be renamed from Department of Education to the Department of Education and Workforce, and the acronym that's used then in this provision and throughout other areas of the bill is to refer to ODE as DEW. The Senate finance version also creates the position of Director of Education and Workforce, and that position is appointed by the governor with the advice and consent of the Senate, and would also be considered the head of DEW. It also establishes different divisions within DEW. One is the Division of Primary and Secondary Education and the Division of Career Technical Education. And those would be headed up by deputy directors who would be appointed by the director with the advice and consent of the Senate. So obviously these provisions bring in the legislative bodies, the Senate and the governor. That brings them into a more primary role in these appointments than what currently exists with ODE. The other interesting thing is this would transfer most of the power and duties of the State Board of Education and the Superintendent of Public Instruction to this newly created DEW. So, you know, in the statement that these rights and these powers and duties get transferred, the State Board of Education and the Superintendent of Public Instruction at this point in time in this version of the bill does not just go away. They will still continue in place. And actually the State Board of Education and the state superintendent will continue to have oversight and continue their duties regarding educator licensure, disciplinary actions, school district territory transfers, and a few other areas. So it will be interesting to see if this makes it into the final version of the bill, where that line of demarcation will end up between, you know, what the State Board of Education and the superintendent will have authority over versus what the new DEW and the new DEW appointees will have jurisdiction over. Certainly, educator licensing is something that impacts school districts in many different ways. The disciplinary process currently under ODE, those of you that have been involved in misconduct reporting and investigations, you know that can take, you know, a number of years really to sort through, whether there will be changes to that process, and the timeline of those investigations are, you know, still yet to be seen. Next slide.
So this one is interesting because neither the governor nor the House had a proposal on this particular line item, and there isn't really much information available to it just yet. So we'll definitely be keeping in contact with Sherri next week as things are further presented through the Senate on this particular item. But the proposal from the Senate is to under 3317.019 and 3317.161 authorize Do, that new version of Department of Ed, for fiscal years 24 and 25 to adjust the funding base of local districts or the funding base for JVSDs as JVSDs are established. It's kind of speculative as to what the Senate's intent is with this, or why the proposed shift from codified to uncodified law. And it's just something that we're going to be watching next week as further activity in the Senate in regards to this particular portion of the budget bill. We're just not a lot of details yet, admittedly, but something that we're going to keep our eye on.
Okay, on the homeschooling front, there are changes being made to home education One being that it does change the reference in existing law from home instruction. That term is used in existing law. That will be changed to home education in the provisions. And the definition of home education in the Senate Finance version is the education of a child between 6 and 18 years old that is directed by the child's parent and excludes education provided to a child who is enrolled full-time in a public or chartered non-public school district. There's other provisions that really seem to make things a bit easier on parents when they seek to implement homeschooling. And so it does require parents to provide notice to the superintendent of the school district of residence within 5 calendar days of beginning homeschooling, or within 5 calendar days of moving into a district. But once that notice is received by the superintendent, it becomes effective immediately. And the superintendent then has to provide a written acknowledgement within 14 days of receiving that notice. Other provisions in this bill include that there is an exemption from existing requirements, academic requirements relating to the participation of a homeschool student in extracurriculars. So this provision would remove the requirement that a student who is homeschooled in the preceding grade period meet certain academic requirements in order to participate in extracurricular activities in the district of residence. It does also, interestingly, and I think, this is probably like one of the biggest open questions in the Senate Finance provision in terms of how this would be implemented, but it does specify that a child who is homeschooled may be subject to the state truancy laws if there is evidence that the child is not receiving the required education. So like anything else that is new, there's lots of questions about how state truancy law would be applied, how that would be tracked, how that would be enforced. So those are all open questions that will need to be answered if that stays in the final version of the bill. Along the lines of making it a bit easier for parents who homeschool, it does also permit a parent of a child who's 16 years and older to issue an agent schooling certificate themselves in order for the minor to work versus having to get that through the district of residence. And I will flip it back to Lisa.
So now we're going to launch into a couple of personnel related provisions that the Senate introduced into their version of the budget bill that were not addressed either in the executive or the House version. The first has to do with substitute teachers. So as we know, we've been operating under kind of some temporary looser guidance with regards to engaging and employing substitute teachers who do not have a post-secondary degree. And the Senate is proposing to make the temporary provisions permanent. Currently, the provisions expire after the coming school year. The Senate's proposal in this portion of the budget bill is to make the provisions permanent, that school districts can employ substitute teachers who do not have a post-secondary degree, so long as those individuals meet the local standards as adopted, generally speaking, in board policy, and also pass the required BCI, FBI, and those related standards. The Senate's proposal also indicates to ODE that the license for these individuals to serve as substitute teachers, those who do not have a post-secondary degree, would be a 1-year temporary license. And also under the Senate's proposal, the Senate is directing the Ohio Department of Education to establish criteria for the renewal of those licenses. So this is probably good news to a lot of districts that have taken advantage of this, particularly those that perhaps are engaging students who are majoring in education in college and might have some extra time to serve in a substitute teaching capacity. So that this portion of the Senate bill may be very welcome news to some districts.
Okay, along those same lines, in terms of adding greater flexibility to a school district to be able to, bring in substitutes and licensed staff members in order to teach their student body. There are provisions in the Senate Finance version that would expand a school district's ability to use veterans that are not licensed as a teacher to teach subjects, including core subjects. So the Senate Finance version does expand the current authority of school districts to employ as a teacher a veteran who does not hold a license. And that expansion, it qualifies a veteran who was honorably discharged from the service at any time. Prior law or existing law, I should say, only qualifies a veteran discharged between the time period of June 30th, 1997 and June 30th, 2000. That time period, that restriction of the time period is removed in this version. And it does extend the authority to hire as a teacher a veteran to community and STEM schools as well. The bill specifies that veterans that would be hired in this manner are still subject to the BCI background checks and the RAP back process. But it does also allow a veteran to teach a core subject area. And to do that, it provides an exception to the existing law requirement that a teacher be properly certified or licensed to teach a core subject area. It does continue to in place existing law that requires a veteran to complete 15 hours of approved PD coursework every 5 years. And it does authorize the revocation of a veteran's authorization to teach if after an investigation and adjudication is determined that the veteran is not competent to teach. And that investigation and adjudication, the revocation, would come through the superintendent of public instruction. Next slide.
So kind of rounding out the personnel focus, well, we have a little bit more personnel focus towards the end, but kind of the heavier personnel items or singular one-off personnel items added by the Senate to their version of the budget bill is on the issue of auxiliary service personnel. I think philosophically, the way that I read the Senate's proposal is that they're just trying to expand the non-public schools' ability to engage personnel to provide auxiliary services on campus, rather than having to rely on the resident district or what have you from providing the personnel. The Senate's proposal basically prohibits the providing school district from denying the non-public schools request for personnel for these services. And so viewing it kind of from a high level, it appears that the Senate's trying to give more control to the non-public schools in terms of how the services are provided under this particular funding mechanism. So awaiting further details, but interesting proposal from the Senate nevertheless.
So before I jump into this slide, I do just want to make mention with all these, various personnel changes, that come with, really kind of good news for districts in terms of added flexibility that, a district may want to take advantage of. But of course, whenever you're making changes to regulations involving personnel, you have to anticipate that you may have some attempts by your unions to weigh in on that, or to get provisions in the collective bargaining agreement that would address your ability to take advantage of those provisions. So I think we need to wait and see what ends up in the final bill, and depending on that, you very well could be seeing some requests to maybe enter into MOUs, or certainly in the next round of negotiations, some provisions from your teachers unions regarding, for instance, the board's ability to use substitutes under the, the new legal provisions. So, okay.
Susan,
yes.
Susan, not to interrupt the train of thought, but do you feel that the licensure grade band proposal is going to stick for teachers? Because the Senate didn't make any changes to it. And do you feel that if those changes to the teacher licensure grade bands remain and pass in some form in the final version of the budget, do you think that would warrant or be some type of a mandatory reopener with the teachers union in that context? Because now all of a sudden, certain teachers are going to have expanded or broadened ability to teach based on the revised grade bands. Not all teachers, but some certainly will.
I mean, I think that's something that, should definitely be on every district's radar screen, that there might be a demand to bargain it. I think to some degree, obviously the devil's always in the detail. So it will depend on, what the final provision looks like in the bill. But, and it also depends somewhat on what a collective bargaining agreement says. Many collective bargaining agreements have that language that says that there's a change to existing law that impacts these provisions. A lot of times that will require parties to reopen on that issue. So I think it will depend on your collective bargaining agreement as well to determine if you are required to midterm bargain something like that, or if you can wait till the next negotiation season. But I think, Lisa, that's definitely something that districts need to be keeping an eye on, and probably reviewing your CBAs now to see, what the potential ramifications are if that stays in the final version. And I mean, I don't pretend to have my finger on the pulse of the legislature. Sherri is definitely closer to that than I am. But given that it was in the House version, still in the Senate version, I don't see any indication that it wouldn't be in the final bill. Sherri, I don't know if you have thoughts otherwise on that.
Yeah, I fully expect this provision to make it through. I know where this provision came from and why it was put in. And I don't believe there's going to be a huge push to remove it. So I think that is a provision that everybody needs to be expecting to implement come post-budget.
Okay, great.
It really would have ramifications, not just in terms of hiring, but also in terms of voluntary transfers, reduction in force lists. There's kind of just a cascading effect. My hunch is that the proposal, best of intentions, to expand districts' ability to cover areas that might be difficult to staff, but there are just going to be other impacts that the expansion has on the grade bands and the eligibility to teach certain subjects and areas. It's going to have a cascading effect on other aspects of the collective bargaining agreement, I would think.
Well, I agree, and especially when it pertains to RIFs, RIF language, as well as potential lateral transfers or transfers, to different teaching subjects and that sort of thing. So it definitely could have, more of a domino effect than on first blush you might think. So, okay, moving to pecuniary interests of school board members. So under existing law, this really implicates, two different statutes. So under existing law, there is a school-specific statute that addresses, as its title, pecuniary interests of school board members. And so what that existing statute says is that no school board member may have a direct or indirect pecuniary interest, aka financial interest, in a contract in which the district enters. So in other words, a school board member can't have an interest in a contract that the Board of Education is entering into with another entity or individual. So under the Senate finance provision of the bill, there will be an exemption written into that, which will exempt school board members who are employed by a higher ed institution. It does require the school board member to recuse themselves from voting and discussing on the contract, and also to file an affidavit stating the member's employment status. So in other words, it has to be transparent. A school board member has to disclose that they are an employee of, let's say, a university that the Board of Ed is seeking to enter into a contract for like College Credit Plus or something like that. So if a school board member discloses their employment, files an affidavit regarding that employment, and then recuses themselves from voting on or discussing the contract, then they will not, under this provision, be deemed to have a pecuniary interest in the contract between the Board of Education and that university. What's interesting to me is then there's also a separate criminal statute, which is the unlawful interest in a public contract, that also applies to school board members just more generally as, as a public official, that contains additional exemptions to that provision. So under the criminal unlawful interest in a public contract, a public official would be deemed not to have an unlawful interest in a public contract if there are certain exceptions met, like i.e. if the goods or services can't be obtained elsewhere, if it's shown that there is that the price of the contract is a fair market value price, those sort of things. Those exemptions are not in the school district, the school specific statute. And so when I tackle these issues for my school board members, it's always a bit of a quagmire in terms of the school specific statute is a broader restriction in my mind than the unlawful interest in a public contract. So this provision of the Senate Finance Bill will add in one exception, which is just related to higher education, but doesn't acknowledge that there are these other exceptions that have been deemed by the legislature to be adequate to exempt a public official from being determined to have an unlawful interest in a public contract, but those are still not applicable to school board members. So you should still have to be very careful as a school board member. If you have any sort of interest in a contract that your board is considering, you have to proceed with the utmost of caution. Next slide.
Okay, the next few slides are going to be somewhat student focused, and these are provisions that the Senate has added that, again, were not part of the executive proposal, the House proposal, but the Senate obviously feels strongly about online instruction during school closure or calamity days. And so this slide sets forth the Senate's proposal. Conceptually, the Senate proposal, after we're done reviewing it, will clearly require, if it's adopted in its current form, bargaining with the teachers union, possible changes to the adopted school calendar, handbooks, and board policy. So there's a lot in the slide. And if there are follow-up questions, of course, we can entertain those in the Q&A box. But first, the Senate's proposal eliminates blizzard bags entirely and lessons posted online for the first 3 calamity days of a school year. Yes, we've been operating with blizzard bags for quite a while, but the Senate is proposing to eliminate that concept entirely and substitute in its place makeup of the first 3 calamity days through a virtual educational delivery model. Each school district under the Senate's plan will be required to submit its proposal or its plan for its own virtual educational delivery model by August 1st. And the plan must have real-time synchronous learning in a virtual platform to the extent possible. That may be very difficult for some districts to scramble to pull off this summer if this proposal goes through as in its current form and there isn't a delay, for example, in implementing to 24-25 school year. If it goes in its current form, some districts are going to be scrambling. In addition, the Senate's version requires consent of the teachers union. Obviously, I mean, this is a complete change in course for how some districts have been doing not only blizzard bags, but asynchronous learning, for example. The Senate's proposal also requires school districts to develop attendance requirements for students during these 3 virtual educational delivery model days. And then for days, any calamity days or school closure days after the first 3, the Senate is allowing local control or local options as negotiated, obviously with the teachers union, for additional makeup beyond the 3. So lots of potential ramifications packed into this particular proposal from the Senate. I personally didn't see it coming. I'd be interested in Sherri's thoughts if she saw this coming, but I didn't see this one coming, and it was definitely an interesting read. When the Senate rolled out their version, just was not expecting it, but there's just a lot here.
So I will not say that I was surprised that I saw this when I saw this provision. The Senate and many members in the General Assembly have been very concerned that the blizzard bags have basically become busy work in order for the districts to be able to count those hours towards the required numbers for a school year, and they want to step in and make changes to that. So you know, it was not a surprise. We'll see if they make any changes to it, or in particular, maybe push off the effective date, or at least when the plans are due. Typically, we don't have schools closed during the first couple months of school, so maybe we can push off the requirement of the plans being in place to potentially in the fall.
Well, and Lisa, what are your thoughts on the bargaining implications of that one? Because, you know, certainly, you know, if the bill in its current form, you know, remains and requires the written consent of the teachers union to the, you know, online learning plan, then, you know, I don't see how that avoids, you know, bargaining with your unions over the summer to get something in place for the school year. And I mean, those of you that have, you know, tried to bargain your contracts after the school year ends and, you know, in the summer months, know how difficult that can be to get folks together. Lisa, what are your thoughts on the bargaining implications of that?
Yeah, I think it's going to be fast and furious, especially as Sherri mentioned, if there isn't a delay in implementation, at least like a 1-year grace period to get everybody's act together.
Right.
I think folks are going to be scrambling this summer, not only to put the plan in place, the virtual education plan, but also, you know, to kind of negotiate and change the school calendar and or accordingly with the teachers union. Yeah, and I think too, to the extent that there might be conflict of law provision and collective bargaining agreement, it'll just be really interesting to see how that all comes together. But this is definitely going to require some work over the summer if there's no delay.
Right. It also implicates calamity day pay, so it could have a financial component, certainly for districts as well. So yeah, this is one definitely that should be watched carefully. Okay, next slide. Just a quick touch on this one. This is just relates to student graduation requirements, and the Senate Finance provision would permit a student to sub out 1/2 of a unit of financial literacy instruction for 1/2 of a unit of social studies in order to meet the financial literacy requirement for graduation. So next slide.
This one's a quick little ditty too, still on the subject of kind of like student focused components of the Senate version. Intra-district open enrollment. So this isn't inter-district open enrollment, it's intra. So meaning in-house, in-district, when students or if the board policy permits intra-district open enrollment, the Senate has set forth 2 requirements for those districts that do intra-district open enrollment. First, there will be new requirements for the district to report intra-district open enrollment students and figures through EMIS. And then second, and probably more cumbersome and more problematic, the Senate will be requiring districts that use a lottery process for their intra-district open enrollment. So inside the district, districts that use a lottery process must conduct that lottery on or before the second Monday of June in the school year prior to the school year of the enrollment. So, and this would have to be delayed because we won't be able to do it. The districts that have intra-district open enrollment and use a lottery process for that won't be able to comply with the second Monday of June requirement for this summer for next school year. So there will have to be a delay provision. But to the extent that districts have maybe enjoyed some flexibility in their use and application of their intra-district open enrollment process, and perhaps at times waived timelines and enforcement and kind of allowed for a more flexible and fluid process for intra-district open enrollment. It appears that the Senate's version in this proposal will eliminate a lot of that flexibility. And then, of course, too, districts that have an intra-district open enrollment process that utilizes a lottery will want to revisit their board policy on that subject to make sure that the policy aligns with any new requirements that might go into the final version.
Okay, so this provision concerns cash payments at athletic events. This was not on my radar screen at all. So I would be interested to hear from Sherri on, if there's any particular background on this. But essentially, I read this provision as, just seeking to provide, to make sure that there's greater access for folks that are attending athletic events to be able to pay cash for a ticket. So this provision, it would do exactly that. It would require a school district that participates in athletic events that are regulated by, an interscholastic conference or organization. It requires those districts to permit an individual to pay cash for a ticket to any event or activity the school conducts, sponsors, or participates in, and for which admission is charged to attend. So, in other words, you have to allow, people to pay cash for a ticket. What's interesting is that you have to give a free ticket to someone that wants to pay cash for a ticket if the school district is not, as a protocol is not accepting cash payment. If there are still tickets available, and if the person that wants to pay cash demonstrates that they actually have the cash in their wallet to do so, if the school district, says, no, we're not set up to take cash payments, in that scenario, if this provision stays in the final version, in that scenario, the school district would have to give a free ticket to that individual. And then this also does reach concessions, and it would require that at least one location of concessions accept cash. And if concessions are on multiple floors of the event, then at least one location on each floor has to accept cash. So, this will, I know plenty of, Friday night football games are moving more towards cashless payment systems. So this would kind of pump the brakes on that to some degree in terms of having to maintain that you can pay with cash for a ticket. I think this implicates, school district treasurers to make sure that there's financial controls for the collection of that cash. If you haven't been doing that as a district for a while, this also implicates your booster groups that may be the ones hosting the concessions, that sort of thing. So this is, also one to watch just in terms of, what it will take logistically to implement. Next slide. Go ahead, Sherri.
Real quick, I think the impetus behind this, because this provision also appears in the higher education budget for all state schools and universities, and I think some of that implication was that Ohio State's football games went to all cashless, and there were some members who were frustrated with that. So good old cash is going to be good in the Ohio education system. It's not only athletics, it's also all extracurricular activities. So your plays, your band concerts, anything in that space that you would be charging admission.
Interesting. Thanks for that insight, Sherri.
So definitely a personnel focused proposal here, but we lumped this particular Senate light item in with a general discussion on transportation provisions. But this one, as proposed by the Senate, is called Bus Driver Flex Career Path Model. There are a lot of issues with this as it was drafted or as it was presented, and I'll kind of touch on those as we go through the content, but definitely collective bargaining implications with this particular proposal if it ends up in the final version, especially for those districts that have different unions that represent bus drivers and the classification of aides, monitors, et cetera. So the concept that's rolled out in this flex career path model by the Senate is the new DO will have to develop this career path model so that bus drivers can work as educational aides or student monitors at a district and or at a school. And in doing so, the Senate is directing due to require or ensure that bus drivers work an 8 to 10 hour shift by either doing a morning or afternoon bus route and then spending the net remainder of the workday working as an educational aide or student monitor at a school. So there are a lot of issues. First of all, possibility for overtime, applying on a daily basis to these employees. It's already difficult enough to find bus drivers to cover morning and afternoon routes under this particular proposal. The way I read it, a bus driver would work a morning route, spend the rest of the day serving as an aide and or a monitor, therefore leaving the district to find somebody different to cover an afternoon route. There's just a lot of clarity needed on this one. I'm not confident that the Senate intended to force districts to pay overtime to bus drivers so that they can also work as educational aides or student monitors, but the way that it reads, it certainly could happen. Another piece that the proposal, I think, leaves to question is if a bus driver is required to be employed as an educational aide or a student monitor under this flex career path, are they also required to obtain an educational aid permit to do an educational aid function? My presumption would be yes. The proposal doesn't really speak to it, just talks about kind of throwing on due the requirement to develop this career path model. There's no provision that speaks to when this would be implemented, but certainly collective bargaining implications could include, but not be limited to, offerings for extra work, how seniority lists are created and or maintained, of course, overtime, and then educational aid permits and who's paying for those and things of that nature. So definitely didn't see this one coming either. And I don't really know kind of the driving force behind it, but it certainly is interesting. And I'm not sure that this one helps school districts quite as much as it might hurt districts, especially when you throw into the mix the need to cover things like extracurricular activities, field trips, et cetera.
Well, I agree. This one could be very tricky for school districts. I mean, I think the issue of dual employment in general, gets to be very tricky for school districts in terms of the overtime implications that Lisa's already mentioned, obviously health insurance eligibility. And when you're, working full-time hours or close to full-time hours, this is often a subject of collective bargaining at, tables that I'm at for school districts with your classified employees. So I think this one could get pretty dicey for districts certainly at the outset and, until things get ironed out. So we're getting close to the end. So I'm just going to kind of quickly go through this. This provision in the Senate Finance Bill relates to student transportation and noncompliance with state regs on student transportation standards. And this continues kind of, the focus of ODE on kind of the power of the purse to try to compel compliance with transportation regulations. So what this bill would do is it would change existing law, which currently describes noncompliance as a consistent or prolonged period of noncompliance, in terms of, determining whether or not a district is doing what they're supposed to be doing with student transportation. So instead of just kind of using that, what I would, consider to be a more kind of vague and amorphous definition of a consistent and prolonged period of noncompliance, it's now changed to a period of, or a district would be considered out of compliance if for a period of time of 5 consecutive school days or more than 10 school days within the school year, if any of the following things occur. So students arrive more than 30 minutes late to school for a period of 5 consecutive school days or more than 10 school days within the school year, a district would be considered to be out of compliance. If students do not receive any transportation at all for that 5 consecutive day period or 10 days overall for a school year, then the district is considered out of compliance. Or if there's non-compliance with other provisions of student transportation regulations. Now, there is an exemption for inclement weather. So if a school bus is arriving late for 5 days in a row because of a snowstorm, for instance, that would not be deemed non-compliant. What's interesting to me on that one is that's pretty narrow, right? I mean, it just deals with the weather. But what about a construction project that might be near a school that backs traffic up, on a single lane road, for hours on end, for instance, that would not be taken into consideration under the existing provision of the bill, which I think is problematic. And then, as I said, this provision is using the power of the purse to gain compliance. So if a district is determined to be non-compliant, then DEW, the new ODE, is required to withhold transportation payments from a district that is found to be non-compliant for each day of non-compliance. And then what's interesting about it is, whatever those funds are that are withheld, the Senate Finance version of this would disperse some of that money to the pupils or the parents or guardians of the pupils who did not receive proper transportation. So they're basically withholding funds from the districts, and then they would disperse that money to the actual parents of the people that were impacted by the non-compliant student transportation. This provision does also require a district to submit a remediation plan to ODE/DEW. And then only once that remediation plan was, the terms of that were met by the school district, would transportation payments resume. So obviously this is one that, districts should also be watching pretty carefully. Okay, Sherri, I think back to you.
Yeah, so real quick, we did have a question regarding transparency with regards to vouchers and students in vouchers. And I believe that what you will see is that will not be restored. The Senate version of the budget clearly focuses or enables parents, empowers parents to make these decisions. And it's not going to, I think, facilitate any type of transparency in this space that they don't believe they have to. On our last slide, there was language in the House version of the bill which removed your ability to put a replacement levy on the ballot. That language was removed, so you still will have use of replacement levies. And then the last thing we wanted to mention is House Bill 187, which is a bill sponsored by Representatives Hall and Byrd, makes changes to the formula that is used to reassess the home values, property tax values, during the 6-year and 3-year updates to property tax values. That language is being talked about being rolled into the budget bill, as there's a great deal of concern over what the increases are going to be over the next 1 to 3 years. We're seeing an incredible amount of increase in property valuation in the state, and that will correlate into additional increases in property taxes. People are very concerned. And what this would do is probably even out or soften the significant increase. So we will be watching for that to go in, and it will be something we will be discussing on the final version of our Road to the Budget, which will be taking place tentatively in July. So please watch for information as the budget moves through. If we either have it finished sooner than we expect and or it is delayed because of conference committee challenges, we will be placing or scheduling that last webinar accordingly. So with that, I'm going to throw it over to Susan for our final conclusion, and thank you for joining us.
Well, thank you, Sherri. Yes, so I think I mentioned in the beginning, we are tentatively scheduled for part 3 on July 6th, but as Sherri said, that date will be entirely dependent on when we get the final version of the bill, so that may change. So please just keep an eye out in your email for correspondence from us on that. Other than that, thank you all for joining us this morning, and have a great Friday and a great weekend.